Good evening. This is a meeting of the Village of Mamaroneck Zoning Board of Appeals. It's a special meeting. It was properly noticed. We're going to have tonight two hearings that are going to be continued and then address some closed matters and other matters. We have quorum tonight. We have Robin Kramer, we have Greta Heaney, we have Brian Gladstein, and myself. We have counsel with us, Charlie Gottlieb. We have Brittany O'Neill, Village Planning Department. And we're going to start with the process that we follow for those of you that are going to be attending tonight is basically as follows. We have two hearings will continue. The applicants can speak to the board. The board will ask questions. If anyone wants to speak after the applicant, we'll provide them with an opportunity to do so. Speak to the board if you would then. When the hearings are closed, the board does not take any more comment on the matter. And at some point, it will deliberate on it, probably within the next 2 months. The board will have another meeting the end of this month. And then I believe the next meeting after that will be in September. The next meeting will have probably, because I don't think we're going to get to our full agenda tonight, because after this, I found that there were two matters on. So we'll try to keep the agenda more limited for the next meeting as well. But the first matter we have on this evening is the application 10 special permit 22, 154 Mamaroneck Avenue regarding Duke's Ramen LLC. We received, since that time, I believe, the only thing we got was a one-page diagram, which is of the interior, showing the seating of 10 counter seats. To my knowledge, that's the only new item that was received. Is the applicant here on this? Not sure the applicant. I'm not sure the applicant was planning on being here.
He's here.
Don't know. Oh, the applicant is here? Okay, could you elevate them, please? Thank you. I think one of the things we also have to address is what type of a restaurant this is, so it can be properly reflected. Good evening.
Hi, good evening. How are you?
Fine, thank you. You have submitted this drawing, correct? Showing the 10 counter seats?
Yes, so I met with Dennis at the location and we went over measurements, aisles, and the spacing of the equipment as well as the counter itself.
Okay. All right. Now, what percentage of the business is going to be takeout versus on the site?
I'm anticipating probably 60% would be a takeout.
Okay. Does anyone on the board have any questions regarding this or any comments? No questions, actually.
Just the drawing. So this final drawing was also done by Dennis Drogan?
Dennis and I, we met and we just measured things out, but the drawing itself, I did myself.
Okay, but these are the actual measurements that you and Dennis
Correct,
did.
yes.
Did
Yes,
together.
sir.
Okay, all right.
And that 60% takeout, that includes the carry out and delivery. Is that
Correct.
what you-
Okay. Very good. Does anyone have any questions concerning this? Does anyone here want to speak to this application?
There are no hands.
Okay. Oh, hands. Everybody should have a couple of those. But Charlie, anything we need on this? There was a question I think we had about the type of restaurant facility. It's a food service establishment, right?
Isn't
Right.
that something that we would discuss once we close it?
Yeah, I guess so. You're right. I was just asking that one. Okay. All right. Is there a motion on this, please? Is there a motion to close?
I'll motion to close.
Okay, is there a second?
Second,
Okay, Robin?
you mute.
Robin, you're
Yes. Yes.
Brian?
Yes.
Greta?
Yes.
Okay, the hearing is closed, and thank you very much to the applicant. We will decide this either tonight, next meeting, in the near future. All right?
Okay, great.
Thank
Thanks,
you.
everybody.
Thank
Have
you.
a great
Thank
evening.
you. Thank you very much. Appreciate it. Okay.
Bye.
Just one moment. The next matter is continuing hearing in connection with trying to get the address here. I don't seem to see it on. It's not 308 Mamaroneck Avenue. And that's application 11, special permit 22. My career from Mamaroneck Tequila Inc. Okay. Is the applicant here this evening?
Drew is here and I believe Mike is as well.
Is that you, Mr. Spatz?
In the flesh or virtually, good evening, Chair, members of.
Virtually, good evening. You are representing them on this, correct?
Judge, oh my goodness, I feel like I'm still in court. I am, Chair. I've been recently retained again. Mike should be on, and one of his partners should also be Brittany, if we could promote them.
No
Oh,
name,
Mike, I
nobody.
see. Okay.
Who's Mike's?
me
partner?
just-
Oh, Kai.
Let me just
Yeah,
point
hi,
out one
hi.
thing. Mr. Spatz, let me just point out one thing. I did get a copy from the village. It was an email sent to the police department from Margarita of the State Liquor Authority, that indicating that there was a notice regarding a focal point for police attention, which is a process whereby if there are numerous incidents in an SLA license place, they notify them. We don't know any of the details, and I have no idea, except that I did have an opportunity and I wanted to just ascertain if it was open or not. And that I did speak with them. First of all, I was surprised we hadn't received anything from the police department before. But in speaking to the attorney from SLA who's handling this matter, she underscored the fact that the basic issue was that there were several complaints regarding the villages that operating outside of the hours, and that this generated, I guess, enough concern that it was referred to them by the local police. It has not been litigated. They've received notice of this, according to her. She indicated that it's just kind of unusual. It was loud music, hours and issues, and I don't know the truth of this. Obviously, it was probably double hearsay at this point. And they occurred in March, April, and May and June. One incident apparently involved someone pushing a police officer. But I have no idea the details. She will get them. You might want to address that because this is an open hearing, and while we don't know about what actually occurred, it's been pointed out that this matter is the subject now of at least a preliminary examination by the State Liquor Authority regarding its operation. Again, it's usually what happens, I'm told, is they'll work something out with them, whether it's a fine or otherwise, but I have no idea what actually will happen any more than the SLA attorney did.
According to the notice that we got, David, the restaurant Barquilla was open numerous times past its operating hours. So
Yeah.
that's, regardless of anything else, we do know that based on the SLA report. So
Did you see the SLA? I did not see an SLA.
Yeah,
Yeah,
report.
it was
actually,
sent-
Dave,
circulated.
Brittany just sent it, and there's a police referral form. There's, since January 1st, there's over 15 occurrences of being open, some of them substantially later than they should, 1:46 a.m., 2 a.m., 2 a.m., 2 a.m., 2 a.m. Where they're
When did
actively
this arrive?
serving.
When did you get this document?
This afternoon sometime, when I looked
5:05
at the
p.m.
village before the
5:05.
meeting, it was on there. When I checked the village, to get my panelist link, it was on the village, it was there.
Yeah.
Brittany, what were the circumstances on how we got this and how this was received?
Sean, I was asked to obtain all the violations. Unfortunately, the program we use does not print them out well. So as Sean was entering ones that we've received from PD over the course of the last couple months, there was a discrepancy on whether or not those were supposed to go into the municity system that the building department uses. Sean was asked to put those in, and as he was entering them, he was having problems. So instead, he gave me those this afternoon to send over to everybody.
When were these first obtained? Do you know when Sean got these or when they came up?
That I don't know. I know we've received PD and we've sent over some emails we've received here and there, but whether they were put into the municity system, which is where our violations are for each property.
Okay. Let's see. They are. Yeah, I don't know why.
Well, Dave, we first got notice that there were issues from Chief DeRusso back on June 6th.
Mhm.
And what happened was earlier this week, I researched that and I asked Brittany to help us out and bring us up to date as to whether or not there's open violations that, we need to know about for this meeting. So I'm very grateful that she was able to put something together. Gives us more information.
Right. Yeah, I guess in the past, we used to just automatically get any from the police on every special permit application. But the only thing I'm seeing posted here is, as of right now, the only thing I'm noticing that was posted would be the email of July 6th to you, which forwarded to June 29th. It's a June 29th email. Which for some reason didn't go to us at the time. All right.
I know Sean had forwarded over a couple of Chief DeRusa's emails over the course of the last couple of weeks. So those were sent around as well.
Are they listed on the?
They were not posted to the website. No, they were not.
Yeah, any reason? Because we should probably post them. I don't know why they're not posted. If they're going to be considered, they should have been, but okay. All right. So we have that. Okay. Well, why don't we let Mr. Spatz, do you want to speak to these things and speak to the application, Mr. Spatz?
That would be great. Thank you so much. And just again, by background, we have Mike Arisi, who is the proprietor of Mamaroneck Barkia Inc. We're joined by Kai Cooper, who has recently been brought in to assist Mike with the day-to-day operation of the establishment. And I want to take a step back, Chair, and I just want to address Ms. Kramer. The documents you made reference to, were those posted for public viewing, or was it just sent to members of the Zoning Board of Appeals? You made references to documents about police reports or incident reports. Were those posted, or is that just received by?
Brittany, was it posted?
The items that I sent, the one email that came in was posted. The items I sent to Brian, I sent them at 5:05. They were not posted. I just received them today.
Okay, so.
Well, the applicant should get those. So the
said,
you should get, Mr. Spatz, you should get those as all other members of the board. And also, Brittany, could you post those as well? So we all have access to them?
So
I
here's
apologize,
the good
Mr.
news.
Spatz, they should have been made available before. Go ahead.
Chair, I understand that. Look, it's a fluid situation. I hate to use the word fluid situation in the Village of Mamaroneck, but it is. I understand that there are a lot of moving parts here. Let me just take a step back. Here's the good news. The good news is yesterday, both Kai and Mike and I met with members of the Mamaroneck Village Police Department, both the village manager, assistant village manager, the building department, to address these very issues. Bless you. Knowing that tonight we were going to be appearing before the Zoning Board of Appeals, seeking an amended use hours that were previously granted back in 2021 of November, and understanding that indeed there were several issues referred to the State Liquor Authority. Now, I want to emphasize this, Chair and members of Zoning Board of Appeals. As of this afternoon, this evening, not one matter is pending in the village court. And I need to expand upon that. And that's an important component here, because previously, last year, the process was the building department received complaints. They were filed, and we addressed those very issues in court. And what I think is important here is that of the 12 violations that were filed, 9 of them were tossed on their face because they were utilizing the wrong resolution for hours of operation. So I can't speak in terms of that's the case this evening, in terms of what you're making reference to. But as of tonight, there's not one matter that's pending. In fact, I appeared in court.
Excuse me, when you
Judge
said
Gallagher
pending
last week.
Go ahead, I'm sorry.
I'm sorry. When I mean pending, nothing has been filed. The Village of Mamaroneck, whether it be the building department or the Mamaroneck Village Police Department, there's nothing pending before the village court with regards to any violations whatsoever, whether operating beyond the hours, scope of hours, safety, life safety issues. There's nothing that has been filed as of today. So right now, what we do have is a civil assertion through the Liquor Authority. That's not criminal, it's quasi-civil. And my client has retained counsel who will be speaking to Margarita Morisco. In fact, I have an email from June 23rd that she's the assigned representative to address those issues. We plan on addressing those issues. More times than not, it results in a fine if indeed there's a finding that there's any type of wrongful action. And the operator generally, unless there's something egregious, will not lose their operating license or the liquor license. The document that I do have in possession is a past inspection dated June 23rd, issued by the Village of Mamaroneck, indicating the fact that there were absolutely no building code violations. And the reason why I'm making reference to that, Chair and members of the Zoning Board of Appeals, is because a lion's share of the assertions in the complaint make reference to safety issues. So we actually, unfortunately, the right hand doesn't necessarily know what the left hand is doing in this situation, because the Liquor Authority was advised of certain circumstances that have since been cured. So that's number one. Number two, with regards to the hours of operation, obviously, based upon what happened previously with my client, I would be curious to see what resolution the individuals were making reference to. As you know, there's a sliding scale here of hours. There's certain times when windows have to be closed, service has to stop, and the premises have to be occupied, emptied by customers.
Mr.
So the
Spatz,
question I have,
Mr. Spatz, let me interrupt you for 1 second, just so that we can expedite this. I just went through every single one of these police referral items. Every single one is either on a Friday or Saturday night. Every single one is beyond the time that the premises have to be vacated. Some of them close, but some of them substantially vacated. So this actually does go on the special permit, which is in force as of November. Every single one of these is beyond the time frame for the November thing. So the whole sliding scale, all of that,
Right. And,
every single one of these is on a Saturday and Sunday.
And I
Every
can
single one is
appreciate that.
beyond 1 a.m.
and I
Just
can
a second.
appreciate
Mr.
that.
Spatz, just a second, let Mr. Glassstein finish.
That's it. I just,
Okay, I would
Okay.
just point out, I haven't seen any of those, and I would like to see them, obviously, as I'm sure Mr. Spatz would like to if you
Sure.
haven't, and other members. The other thing is that I'm told that the incidents that the subject of the focal point pleading that's been filed is occurred in March, April, May, and June of this year, 2022. And while most of them dealt with, and again, I haven't seen them. I was verbally told this by the attorney, and I don't know what that attorney knows about it, actual knowledge, but also loud music, hours were the repetitive ones. And there was something about a police officer who was pushed in June. I would only tell you this, that from my standpoint, you're now seeking to change the hours without seeing and looking into this. And I'm not suggesting these have been violated or not, but I need to know more about these pending matters. And I'll request them from SLA, and they said they would provide them, but we need to know more about it. I think given the focal point charge, which is basically a charge that arises out of when there's a series, excuse me, there's a computer mine broke. There's a series of violations of some type that they will then bring it because they say you're a focal point for all of these things. They don't necessarily mean anything serious, but they could be. We have no idea. I'm not prejudging it. It's not ours to judge. But to ask for a change of hours, and we know this is a focal point analysis, seems to be at this point, during an open hearing, we ought to basically defer this, put this off, and see what occurs with the other matters so we know what they are.
Let me just, if I can, on behalf of the applicant, and I'm sure, and to address Mr. Gladstein's position is, we had that situation as well previously, Mr. Gladstein, and based upon the surveillance footage that we had, some of our charges were dismissed because the individuals that were depicted or reflected in the
But he's not talking about those.
establishment
We're talking
or
about the
employees.
SLA ones.
So my point is this, the assertions that there was operating at 2 a.m., 1:30 a.m., I have not had the chance, and we certainly have not had a chance to, detail that. So there is a presumption of innocence here. I mean, of course. And this, again, may be a situation, quite frankly, that I understand that council will address the issues with the state liquor authority. I will personally be dealing with the matter. If indeed there's a matter pending or filed with the village, we'll, advocate and obviously zealously defend the establishment. What we have here tonight, and respectfully, what we have before the zoning board tonight is an application seeking additional hours. What we don't have is there is no finding of guilt. There may be assertions, but that's all they are. And what I would suggest to the board is that we should continue with this process. And obviously, once indeed if our application is granted or thereafter, if the board feels there needs to be a probationary period where we could be called back in and the times could be revisited, that's fine. But I do find that this, as I made reference to during the meeting yesterday with our village, the cart is being pulled ahead of the horses. That there's nothing pending locally, and this is a mere civil matter with a liquor authority. Now, let me just take that step further.
wait a minute.
Mr.
Let's assume the
Spatz, let me
liquor
say,
authority-
I don't, when you say that, I want to be clear as how I feel, because I don't know, can't speak for others, but to say that it's a mere civil matter, I'm not, it doesn't affect me whether it's civil or criminal. I mean, it might have a weight issue in terms of it, but to me, they're basically, and I think we've gone over this, is the allegations are such that the SLA has commenced proceedings based upon a series of violations of time, of noise, and of a police officer apparently, and I haven't seen anything on it being struck, excuse me. So I can't tell you about that, but I think that if otherwise it's a matter of, I don't see how we can consider this, give you the hours. First, they got to deal with what the present status is.
As I see it, Mr. Spatz, the issue is very simple. You're saying to us, give me the hours and then I'll prove that I can comply. Unless we're satisfied that your client can in fact comply with hours, whatever those hours are, whether you think the hours are unreasonable or you think or they're not, if your client can't comply with whatever standards we have established for them, then we would not be, can't obviously speak for the rest of the board, but I personally would not be interested in granting longer hours when they can't even comply with the shorter hours. Now, I understand that you haven't seen them and you don't know, but based on this applicant was here before we've had issues with this applicant, I think it behooves you to investigate these dates, find out the specifics relating to what was going on those dates. Were they closed? Did they close on time? Why were they open if there was an allegation that they were open? And that's what we will need. Certainly that's what I would need before I would be willing to consider any extension of the current hours.
I fully agree with Robin, but I have a question before we go ahead. What's the difference? And this, I just don't know. What's the difference between an SLA proceeding? Why would the village, refer a matter to the SLA as opposed to the village court? What's the difference between the two?
Great, it's my understanding. Mr. Spatz, do you want to answer that? Or do you want me to? It's up to you.
I'll defer to the board and I'll opine.
Okay. Well, what I understand is that the SLA proceeding is a different proceeding because it deals with licensing of the liquor license or whatever license they have for alcohol. And the police have the opportunity when there's a bar or a liquor, an organization or an entity that serves liquor, and they find that there are regular series of events that are taking place, it becomes, they say that could be a focal point of problems. And they file a pleading for that. And as I told you, when I inquired as to the purpose, all I was told was that a complaint was served on your client, I guess, or on the entity, and that they have an opportunity to be heard and they'll discuss the matter with them, and that the basic charges involved that made the focal point, made the police refer it, concerned, as I said to you repeatedly, is loudness, hours, and apparently a pushing of a police officer in June of this year.
So an SLA proceeding is more serious than a referral to the village court?
Well, it depends. I think that an SLA is more serious in terms of keeping your license and not being fined. I'm not sure. I don't know. The seriousness is really too subjective. I would think so, but it depends on if they don't want to serve alcohol, probably not. But I don't know. But yes, it basically is, and it's a referral made by the police department. And
right, and that's my point on this. I do think that Mr. Spatz and I do believe that the applicant should have the ability to address each one of these things, and I think that we have to make decisions only based on facts. The fact that this is an SLA issue, not really my focus here. My focus is that our chief of police, our local chief of police, and our Mamaroneck police officers are making statements showing that the applicant has been unable or unwilling to comply with the hours that we set in the special permit that currently exists. So, until that matter is is cleared up to see whether or not the applicant can be compliant. I don't have enough information to make a decision as to whether or not to change those hours. And I'll also say, and it is a timely issue because time marches on very quickly. The current special permit, I believe, expires by November of this year. And I think that I think that has to be that also has to be November 5th. Well, yeah, November 5th, 2020. So it was initial probation period. Yeah,
2 years.
so
That's
November 5th.
20.
Yeah, 2022. So I don't want to keep seeing this. I don't think that's expeditious. I think you need to not only come back and ask for hours, but I think at this point, you're going to need to ask for renewal of the special permit because it's not it's really not very good for us to be seeing an applicant once or twice a year, over these matters. So I really think you've got some housekeeping to do before you come back. I don't know if you have any questions from us as to what information we may be looking for, but that's just my opinion on this.
Yeah, Mr. Spence, I'd also say that this doesn't go to the merits at all, but it goes to the fact that when someone's asking for long hours and they've got charges pending against them, regardless of whether they may or may not be in the village court, they could be in the state, they could be anywhere. In this case, they're with SLA and they relate to the hours. Certainly, that's not a record that we have before us that makes at least me comfortable with saying, well, let's extend them. What it tells me first is if they're true, then there's been no respect for them, so there's a violation. If they're not true, then you'll deal with that. But I would, my preference would be that you come back in September and you come back with a deal with this. If it's over, if it's not resolved, then you can come back in October. But it's not a comfort zone to change something like this. This is, instead of being narrowed, and this is going the other way. And I agree with you that I'll take you at your word that it's not happening in the village, but the village court, but it is happening and it is taking place. So you should address that. You say your clients retain counsel, then deal with the matter and you'll see where it goes and you'll let us know. But I'm not comfortable considering an extension of hours.
Chair, and I can appreciate what your concerns are and members of the zoning board as a resident, a member of this community as well. It also concerns me, and Mike and Kai were present at that meeting yesterday that we had with the village PD and members of our village. And I want to point out with the reference to the village court, Chair Newfield. In fact, again, I appeared in court last week expecting that we had indeed a matter pending, but it wasn't. And we were hoping to address that so that I would be able to report to you this evening in terms of what the status is. With that being said,
were you aware of the SLA?
Mr.
Were you aware of the
Gladstein
Mr. Spatz? Were you aware of the SLA proceedings last week?
No, I was not aware to them until this
I believe
week.
I believe they were commenced a month ago, right? I guess the end of June, not a month ago. I'm sorry. Okay. Well, I think that's what you're going back constantly to the same thing with the village, and I understand what you're saying that the majority of them were dismissed. That's fine, but I think
no. Chair, that's something different. I'm totally talking about we were advised respectfully there was a matter. There was a chart. We were take a step back. There was a docket June 13th, 2022 that required my client to appear on the 28th of June last week to deal with life safety issues, which that's why I was making reference to the inspection that had taken place, and overcrowding. We appeared in court that day, but nothing had been filed as of yet. So, that's my point, is there's a lot of moving parts here, and I agree. We will respectfully adhere, or I shouldn't adhere. I'm going to look at the tea leaves here, and it probably would be best that we clarify some of these underlying matters. I would like the opportunity, if Kai would like to be heard this evening, gentlemen, but I just want to caution you, because there's a quasi matter pending. It's civil in nature, but it is a matter pending with the state liquor authority, and nothing is filed yet in the village, but anything we say tonight could ultimately be used against us down the line. So if you want to address the board, I don't want to stop you, but I just caution you that this is recorded. This is a public statement. Anything you could say could later and subsequently be used against us. So.
Well, I'm not sure what the point of going forward is, okay?
Well, Chair, I just want to make sure, again, this is an emotional, part of
Okay.
this goes to the operation of the business of, I'm just trying to make sure that they don't feel I'm dictating, or I should say monopolizing the dialogue with the board. I want to make sure that
Okay,
they
well,
don't have
before
any
we
questions
do
for
that,
you.
let me just poll the board on this thing. Does the board feel we should just adjourn this matter over to September? Or do you want to hear? Because I mean, I'm not seeing what the,
In the past, when we've had issues come up, it seems to be the practice that since they showed up, we let them speak. We're not going to take any action on it, but if the applicant is here and wants to speak, and maybe there's members of the public who are here, and let them speak. We don't have to vote on it. We don't have to make a decision on it. We can just adjourn it after that. But I think since they're here, it would not be unreasonable
okay.
to let them speak.
Greta, what do you think?
I agree, Robin, that makes sense.
So, just a good evening. I'm Kai Cooper.
Hold on, Kai,
Okay, Brian,
before you begin. I of course agree with the fact that we're here and you have the ability to make a statement. And we will take all information into consideration. But I want to further what Attorney Spatz recommended to mention the fact that we are not closing this meeting.
Right.
And that's a very important distinction here. We're not closing the meeting. Were we to close the meeting, then you couldn't present any more information or make any more statements. So yes, you can make a comment tonight, but we're going, I think the board is saying that we're going to keep this open. And you have the ability to think about things and to make statements in the future as well. No opportunity is going to be shut down on you this evening. So if you wish to make a statement, then fine, we're here, but understand and think about what your attorney recommended.
yeah,
No,
let me just add to what Mr. Gladstein said, because it's how I feel. To me, making a statement to going forward on your path, I'm not sure what the purpose is, since you're not getting a closed hearing tonight and you're not getting a decision. So you're going to have to come back and I think it would be much more helpful after you've addressed these individual items to come back and speak then. But I'm not sure. It's like a no-win proposition for you to speak now. That's the way I see it. But, obviously, if you want to say something, take a few minutes and speak. But again, it's as your attorney, I think, acknowledges, there's not an upside here. No one's going to vote in the future if everything's all worked out based on what you said tonight. It's not substantive. It doesn't go to the issues at hand. And
with that said, then I'll defer to
but that's up to you.
I'll defer to the advice of my counsel.
And
Chair,
by the way, I'm not dissuading you.
Chair,
I'm just speaking factually as I see it. That's all. Okay.
So if I can is there a way that we could, rather than moving this to September, you made reference to a July date. Is there a way that perhaps we could move this to the end of July and see if there's any movement this week and next week with regards to the SLA?
If you resolve, in other words,
that would be
everything. In other words, if you resolve the SLA matters and the open matters by the end of July, I guess we could put you on for that, as we'll continue the hearing then. But with the understanding that if they're not resolved, then it will not be.
David, we got an email from Brittany that said, or you asked how many new matters there were, and I think she said there were 4 already new matters, plus we may have other continued hearings. We may have, I just don't know whether I think it was 4, I could have miscounted.
All right, so then, yeah, I don't see this. I don't see how, unless you have a magical way you can explain, Mr. Spatz, how in the next 2 weeks you're going to have this resolved entirely. You haven't even answered the pleading yet with the SLA.
And the good news is, Chair, is that we don't. The attorney is going to engage with discussions and hopefully resolve this matter with Margarita. And that could take, I mean, that could be done in a matter of a week. I mean, that's my point, is that this is not something that has to be prolonged. If counsel engages in meaningful dialogue with the liquor authority, with this individual who's already communicated the fact that she's prepared to do so, you know, one of the pleadings may be nothing related to noise or after hours. It may be to one of the safety issues. My point is,
you said that they've already had communications with her.
what I'm saying is she's already made, she's going to be the agent involved in this matter who will be in a position to resolve if indeed the parties want to resolve. Now, you make a point, Chair. If my client chooses, you know what, forget it. We're not going to take any type of disposition. We're not going to plead out to anything. We're going to have a hearing date. You're right. This thing is not going to get resolved for a really long time. So
yeah,
my point is,
that,
I'm trying to be optimistic. I have a client, who really want. Okay, so you get my point.
You also have a
Ms.
client,
Kramer,
sir,
I get it.
You also have a client that has many times has many issues have been raised as a result of which these proceedings have taken place, regardless of whether they're meritorious or otherwise. So I just can't see, if we have other matters pending already for the end of July, I think that it's, I'm not totally against it, but I just can't see why this should go on before September. I mean, Greta, do you have any feelings on that? You think end of July is carry it for that?
I think my guess is end of July is really unrealistic.
That's what I think.
I think that there might be.
And listen, and
just a second, Mr. Spence. Brian.
You know, there are certain submission guidelines for information.
Yeah.
And as you can see, you know, that's what that was a bit of an issue tonight. And I don't want that to happen again. I don't want to get something 2 hours before the meeting in July that we have to consider. It really should be within the deadlines, and Brittany is very on top of that. And in addition to that, I also want to say the final disposition by the SLA isn't necessarily what my opinion is going to be based on. My opinion is going to be based upon the observance by the Mamaroneck Police Department of operating beyond the hours that they're supposed to. You know, those are the facts that I'm concerned with, regardless of whether or not you make a deal with the SLA. That doesn't prove to me that, you know, you've been able to comply with the hours. And again, I'm also advising your whole special permit is set to renew by November.
Yeah.
So I don't think we're going to be able to make July. I don't think it's realistic. And if you're coming in September, I think that we have to really see what we're going to be doing with this business going forward.
so let me ask some questions here. With regards to the renewal, I understand that 4 months. Brittany, should we submit, or Charlie, should we submit a new application for the renewal, or should we amend?
Okay, we'll deal with that. We'll deal with that later on. Mr. Spatz, you can deal with that later. I think probably should just talk to counsel, but I think quite frankly, you're going to be doing, you might as well just go for the renewal at the same time, the renewal of the amended hours, because otherwise it's going to be October, and then you're going to have a 1 month period. You're going to have to start the other one. But for right now, I think it's the consensus of the board, we're going to go to September for this, and you'll notify us in advance if you need more time. Otherwise, you will get us all the materials. And I also want to just say something to you, Mr. Gladstein said, that I want to concur with. And that is, you may be able to, if these allegations have merit to them, and if you're able to dispose of them in a way that's favorable to your client, that by no means results in the fact that, oh, we're thrilled with that, because it goes to really the existence and the basis for those, because they impact other things, this being one of them. Okay, so we will go to
So my
September.
question, that's my second question, if I can, before we adjourn for the evening. Mr.
Okay.
Gladstein and Chair Newfield, when you talk about observations and what the merits are going to be, are we, I mean, for example, if they have a complaint on such night that they were opened until 2 a.m. and it's our position that those were not guests, those weren't patrons, those were actually employees that were within the premises that were observed from the street, are we to bring this evidence to you?
Mr. Spatz, you've been before us. Mr. Spatz, you've been before us many times, and you're an excellent attorney, and you've done well,
Thank you.
know how to present matters to us. That's something you deal with.
All right,
Okay,
I understand. I just
you
want to
know,
make sure that.
I mean, you bring whatever you think is going to help your client. That's what you do.
Very
But I
good.
think the first step is to address all of these pending matters that have taken place. So
Got it. I
we
hear you
call
loud and
concur
clear.
then that September, it will be on for September. And we will give you another month if you need it. And I think what you should do is you may want to take the additional time and you may want to amend your application, Charlie, because they could do that, right? Amend it to include a renewal of the permit.
Yeah, that's been done in the
I
past.
would like to do that.
Yeah, I would think that
Thank
would
you.
be, because otherwise you're going to be, you might as well just move in and make yourself comfortable. Thank you, Mr.
Why not? I have
Spatz.
nowhere
Thank you
else
to
to
the
go
applicant.
now. Thank you. Kai, Mike, I'll follow up with you.
Okay.
Before I log off, just out of curiosity, and if this goes to Chair or to Brittany, I have a closed matter, 830 Orient Avenue. I don't need to stand by because it's a closed hearing. I don't need to be, that's correct?
Nothing has changed. You are familiar with the fact that we don't take new matter, that we don't take in evidence afterwards.
Just want to make sure. Wonderful. All right.
Nothing has
Have a
changed.
good night, everybody.
Thank you.
Great to be back in the,
Wait, should we check to see if any members of the public want to make a
Yeah, does
comment?
anybody here want to speak to this? Because we're going to put it off. I mean, well, Brittany, is anyone here?
Oh, no hands.
Okay, thank you.
Good night, everyone. Take care. Have a good
Okay, thank you. All right.
rest of the
next-
summer.
That ends the hearings that we had. We have some closed applications. I guess first one is 243 Madison. Forgive me, I had to relocate because of the computer issue. Found out the worst thing about a computer is when the screen goes. Okay, that's the 243 Madison is area variance. It's 06 area variance 22. We actually I believe we have a draft resolution that we were looking at that we had discussed.
Yes.
We had asked if we prepared. Why don't we begin our discussion on that? Anyone want to speak to that, please? Brian, do you have any comments on the application?
Well, yeah, I think we,
On the resolution, I guess, the proposed resolution? that
on
we'd
the
have?
resolution, I had, let's see, green space present, increasing landscape. I had some notes on here. I think that he had most of our thoughts. Look, the most important thing is, is it accurate to the variance that they're asking for? And it seems to coincide with my notes. With the 0.87 and 0.7, when it and the 3 stories to 2.5, and in terms of all of the peripheral justifications, you know, I did see it in there too. Most of the neighborhood is 3-story buildings. The fact that they're doing the 3rd story is in part going to give the property some more pervious surface, which is something we're always looking for. The FAR change, I think, is insubstantial, given the fact that part of it is really to accommodate the parking underneath the structure as opposed to paving the yard and putting a car there. You know, I didn't see anything about flooding in here, but I'm not sure that it needed to be here. You know, it is a new development, you know, a new building, and it is built above the floodplain, but that might just be superfluous. So I, you know, aside from, you know, any little details that somebody else on the board may find with the language, you know, in general, I think it does what it's supposed to.
Okay. Robin or Greta, any comments?
I agree with Brian. I did have some specific comments on a couple sections on the resolution, which I'll be happy to share right now. Just a couple sections, not really nitpicking. On page 3, the top of page 3, there's the very top, the very first line, there's a subsection D. The area variance is consistent with other residences in the neighborhood. I think that's overly broad, and the concept is actually covered in letter B above, preceding it. So I would cross off that D as just overly broad and already covered in more detail in B.
Yeah, I agree with that, because
Yeah,
I'm not sure whether or not we actually have done an analysis of the area variance of everybody in the neighborhood.
And then on 3, this gets to the question of whether the variances are substantial. And, you know, one variance is arguably 25% variance and the other's 20%. Arguably, they are substantial, but it's a balancing test. So the fact that they may be deemed substantial doesn't mean that we wouldn't give the variance, because we're balancing it against other factors that are important and that would override that. So in my view, the variances are substantial. So I would not say are not substantial. I would say that they are. Simple as that. I would cross off C, because that doesn't really deal with substantiality. That's more of a balancing issue. So I would cross that off. They're substantial. That's what they are, you know. But there are these other factors that, you know, when you balance them together, we think it's important. And the applicant has made his case to go through with the project. Then the other comment, so I'd, as I say are substantial. I'd cross off C, because that doesn't. 3C. I cross that off because that really doesn't deal with substantiality. And then under 4B, you still have that language. The area variances are consistent with other residences in the neighborhood. Again, I would cross that off for the same reason we discussed above, and I would replace it with something to the effect. And I think this is an important factor that we should include in the resolution, that the current structure on the premises have been deemed, and this is a quote, an unsafe structure. That was something in the documentation we had. So it's been deemed an unsafe structure.
That's an excellent point.
And it's, I don't know what the best word for it, but visually it is unsightly, or visually it's, you know, it's not, you can say it's unsightly, or visually it's, I don't know, maybe just say it's unsightly. It's been deemed an unsafe structure, and it's unsightly. And that would
the
go
whole property
to,
is blighted right now.
It's what? The whole property?
It's
Well, yeah,
blighted.
whatever. So whatever language you want to use, though unsafe structure is something that was in the document.
Unsafe, yeah.
Yeah, unsafe is all right. Robin? Oh, I'm sorry, Greta, were you finished? I didn't mean to cut you
Yeah,
off. at all.
that was it.
Okay, you had that conclusory tone, so that's why.
Yeah, no.
Before we
And Robin.
move on, I added what you had just mentioned, Greta. But going back to the substantiality of it, do other board members agree to change that from not substantial to substantial and to strike the subparagraph related to totality of the circumstances?
You're talking about 2A? No, I'm sorry,
No, we're
Three.
talking about 3AB.
3, I'm sorry.
Or three.
Well, I think,
Three.
I think 0.17 is really not substantial for the FAR.
It's 20%. It's 20%.
I'm with you, Brian. I do not think it is substantial. The fact that it's 20% doesn't tell me that it's substantial.
Right.
You know, in another application, you might.
Well, you
think
could,
that is
you could say,
substantial.
instead of,
You know, it kind of gives the board leeway as they view substantial to, you know, you have another application that is 20%. You may deem that substantial and somebody can go and then refer to this resolution and say, hey, you're saying 20% isn't substantial.
yeah,
I think it just gives us wiggle room to really define substantial and then use the balancing test, which is the whole point of the area variance.
yeah, I think,
Does the board really want to make a definitive decision as to what the board considers substantial? Are we taking, Greta, are you asking us to do, say, as a matter of law, which is what you're doing, as a matter of, I guess it would be law, I'm not sure. We, the Zoning Board of America, hereby determine that any variance of more than X% is substantial. I'm not willing to make that.
Well, then the flip side of that is you're saying it's not substantial.
But we've
And that
done this.
will be binding us.
so
I
can you
mean,
say it without referring to the percentage? Can you say it that under the circumstances and balancing it without calling it substantial?
right, see, and I think that's
And
where
then-
that's where C comes
Yeah.
in, where it says,
Right.
instead of A and B, you know,
Right.
you lead off with C, looking at the totality of the circumstances.
yeah. I think
You
Brian's
know,
right.
we find that in this specific case,
Yeah.
so
what are you looking at as the totality? Because this factor is just dealing with substantiality.
well, it says because the design of the building will increase green space and allow for more landscaping by having vehicles
But
parked.
that's another factor. That would be a factor on, you know, one of the preceding paragraphs. This paragraph is really just about substantiality.
Just so I can clarify why I put that in there. There are cases, I think about 3 cases that specifically evaluate the substantiality test, and where the Zoning Board of Appeals in those cases have found area variances to be substantial. But the court then says that when you're assessing substantiality, the board can look at the totality of the circumstances, even if they're numerically substantial. And so that's why I put that in there, because the totality of the circumstances is appropriate to look at when you're evaluating substantiality.
Okay.
So you're saying, looking at the totality of the circumstances, it's not substantial. That's what you're referring to, Charlie, correct?
Yes.
Yeah, I think that's because the design, the green space, right?
Yeah,
I don't
And
think,
I think that works. I think, and the condition, the unsafe, I mean, dealing with the totality of it, it's not substantial. Because you don't want to preclude yourself from having someone at 20% or 15% where it is under the circumstances seem very substantial.
and what I like about this, and you know, it's what I had said in the beginning, is the reason for these variances, the 0.17 and the 0.2, you know, which is basically adding a half a floor, is specifically to have parking underneath the building. It's not for any other reason. They're not actually increasing the square footage the living space in the building. And I think that that bears mentioning, and that, and I know that the balancing test comes in later, but, this does significantly point to the fact that the only reason why these variances are being asked for is because they're putting parking within the structure,
Right.
as opposed to outside. And that is relevant to me because it shows that it's not just the variance they're asking for, but it's why they're asking for it.
Would it be helpful if we put in under the totality of the circumstances, including the benefits to the property?
Well, that goes to the weighing, which,
Right.
Greta's saying that's the weight test. I think
Okay.
that here it specifically says, that the area variance is, it's why they're asking for these area variances. It's,
All right.
structurally design.
So let me ask
So
you,
we-
Charlie, could a future applicant come and, ask for an area variance with, comparable percentages, and then say, well, look, you did it, and for whatever reason, we had we viewed those variances as substantial. Could they come back and point to our statement here saying that they're not substantial, and say, no, you're bound, you made your decision and you're bound by that because you're saying these numbers are not substantial?
Sure. So first of all, the cases that I've reviewed say that the 20% threshold is kind of the balancing number of whether or not something is substantial in the court size. If you're over 20% or if you're under 20%. Related to whether or not this board is setting precedent, you could change that in the future. You just have to set forth the reasons why the application that is before you is different than your previous determination. So let's say you have an applicant coming in next month seeking an area variance for 20%, and you've previously said this 20% is not substantial, but for this one is substantial. You would just have to set forth the reasons differing the two applications, and then the precedent wouldn't apply.
I thought 15% was like the borderline. Is 20% now the borderline?
Well, it's been a while since I've reviewed those cases, but 20% is typically the guide that the
Okay.
area variance standards are run by.
Did not think there was actually any court determined standard whereby the New York court said X percent is substantial and Y percent is not. Isn't there, from all the variances that I've read, all the variance cases, I don't recall ever seeing a case where the court definitive, in a particular case, might say this is substantial and this is not. But the court doesn't say this is always substantial. This is the number. You cross over this particular dotted line, you become substantial. That's not what I recall from my reading of case law in this area. So, and I think that's what Charlie is saying, in the sense that it's not a finite line. Like, we're not saying X is substantial and anything over X is always substantial and anything under X percent is never substantial. I think we're saying whether something is substantial can depend on a variety of things.
And again, I think that the focus of the paragraph has to be that the area variances are not substantial, for the following reasons. And the leadoff reason has to be that the structure is being built, these variances relate to the fact that the parking is being put underneath the building, much like all of these surrounding structures.
So to make it easier, the board might consider taking out the two paragraphs completely that deal with the numerical aspect of it, and just leaving in that totality of the circumstances.
All right. That sounds like
Yeah.
the record speaks for itself.
That's kind of what I was saying, when we started this, when we pointed out that section.
All right. So then let's move forward on that basis, possibly, unless there's objection, because we really, I think that I think we can be. We have a record, so we know what we've been discussing, and there's a record there if there's a challenge. So we can reach a conclusory basis on the record, correct? How would you then? You taking notes, Charlie? I mean, I've got no. I'm just not sure where we
Yeah,
all stand on this.
I'm editing the resolution as we speak in
All right.
chat.
Yeah, because it's repetitive. We know
Yeah.
what
Right.
variances they're asking for.
Okay.
Why do we have to call them out here? We don't. We just need to say why we think it's not substantial.
Right. Well, and I thought your current unsafe structure, that's important to put in.
Well, it's very important.
I
Yeah.
agree with you. Okay.
I added
So
that.
Charlie, you want to just really quickly just tell us what changes you made on that so we could kind of reach go forward on this?
I struck subparagraphs A and B and kept.
Oh, what paragraph numbers, please?
I struck 3A and B and kept 3C and added the same language to that paragraph about the unsafe structure and the premises being blighted. And added, therefore, reconstruction would be a benefit to the premises and the neighborhood.
I have
That would be under
a problem
4B.
with that. I don't understand why we're taking out the reason that the variances are not substantial. We cannot just say the variances are not substantial because looking at the totality, because the design will increase green space. Suppose they were increasing the area of the FAR by 75% over, and yet they were increasing green space. I don't think we can just say C. If I understood what you just said correctly, all it's going to have is C in there, and I'm absolutely opposed to that change.
Okay. How do
You have
other,
to say
why don't
what
you
it
go
is.
through the other changes you made, Charlie? Let's go. We're gonna.
Well, that you're putting that unsafe structure
well,
under 4B, right, Charlie? That's under
Yeah.
4B.
Under 3,
I put it under 3C and 4B. I thought
Okay.
that's what I heard.
Okay.
And actually, to Robin's comment, for 3A, I think it's very important to have in there. It's not
Yeah.
substantial because the resident is under the permitted building height.
Yeah.
You don't need to have any more than that. That's a relevant factor.
True.
okay.
No, that's not, the problem with that is that means anybody who wanted to change their 2.5 stories to 3 stories would say, we're done, we can get that variance clearly because you just said it was essentially said it wasn't important. I don't think that's true. Just because you're under the permitted height, the village code specifically has a height limit and a story limit. And if we're going to allow a variance from the story limit, it's not enough that it's under the permitted height, or it could always be under the permitted height.
Well, that's not the sole reason, though.
That's not the
They
sole
just said
reason,
to
right?
take it out about it being 2.5 story because of the cellar. That is relevant to this substantiality.
Okay.
I'm not
So
sure.
you're
I don't
just
understand
saying,
why
you're
we're trying to-
saying you prefer to keep that in.
Yes,
Okay.
Which part of it? What part of 3 do you want to keep in, Rob?
A, B, and whatever. A,
I mean,
B.
that's fine. I mean, if Robin feels so strongly,
Yes,
fine.
yes. Okay, so A and B you want in there, and C goes to the unsafe, right? Blighted, correct?
Yep.
And C is written is out, right? Okay,
The only
yeah.
The only thing
okay.
I'm unclear on is, as written, it says numerically both area variances are not substantial. So let me know if that needs to be changed.
Where does it say that?
Well, I haven't changed 3A or 3B. Greta's concern was that we were calling them not substantial, but in actuality, she believed that they were on a numerical basis.
On a percentage, both of them?
Yes, because one
Yeah,
was 20%, one was 25.
Right.
Wait, one is 25?
Yeah, the
Now,
story.
the story, the stories, I kind of
I
figured.
thought that's 0.2. I mean, it's
0.2, I think is the 0.17.
no.
0.17.
3 stories, you have 3 stories and then you're
Well, you got 2.5 stories, right?
2.5 stories.
2.5 divided by 0.5. Oh, I think I did that backwards. Sorry. It's going to be 20%. It's a 20% increase. Not 25%.
Let's see.
It's
20%.
it's a 20% increase.
Right, that's a 20%. Okay, the other one is like a 25, it's a 24% increase.
No,
Which is that? I'm
I
sorry.
switched them over. The
8?
0.17 is 24.2%, and I switched them over.
I don't know, you're saying the 0.17 over permitted FAR is a
What did I
24%?
do?
Yeah, I'm not.
Oh, yeah, I did,
All right.
and that's how I figured it out.
Charlie, the 0.17,
0.17 divided by 0.7.
24%.
and I would take out
That
the
is
word
right.
only.
24.2, 24.3.
Okay.
0.3.
The 24.2 over the permitted?
Yes. That actually gets to be a bit. I thought you had said it was 20%, and 20%.
I had switched the percents.
Charlie, you following that?
24%. See, now I'm getting to the point of, to me, 24% is getting to be substantial.
I understand, but you're balancing in this, right?
It's just a lot. It's a big percentage difference.
Yeah. Go ahead. Charlie, were there any other changes? We'll come back to that, or?
Wait a minute, I'm taking back something I said, which is talking about it being substantial. I think that Greta was correct in saying that the 24% is substantial. I agree with her. And then in the balancing test.
So then you'd say that it is, while it may be substantial,
It doesn't matter.
right?
Right.
But use better words than it
I would-
doesn't matter.
Right, I understand that.
You know, I'm getting less than 20% on that though, Greta. If you have 0.7,
24.3%. She's right.
right, if 0.7 is permitted
Yeah,
and they're asking for 0.87.
the
Oh,
difference is 0.17.
yeah. Okay.
Charlie, you with him?
Yep.
So it's while it may be substantial, okay.
Yeah.
All
I
right.
just did math that made it 124%. So clearly I shouldn't.
There
be-
you go.
It's very substantial.
Extraordinarily substantial. And it will tower above. Okay. Anything else?
We haven't gotten to Robin's comments yet.
Robin?
Surprisingly, I'm sure I don't really have comments. I only have one comment, which is.
Well, then
that-
you have to take back the first part of your clause.
I don't really have any comments, given what I usually have. I would say that is completely within that. And my
Oh,
only
there's
comment,
less than 10. Go ahead, Rob.
which now I can't find. I have to find it. Because while I know Charlie had sent it to us sometime this week, I find the village website impossible to use. And since I didn't download it when Charlie got it, I was never able to find it again on the village webs on our emails, which means I only had the one that was posted, to the public. And it's ridiculous the way it merges all of the emails.
I reorganized my email settings for the village
I
email,
tried to
and it's
do
made
that.
it a lot easier to.
Okay, well, let's
email.
continue on this, but I would appreciate you sharing that later on, Greta, with all of
Yes,
us.
please.
Because I have a very difficult time.
Yeah. And as a result,
And I
I can't
don't with
find it
anything else I use, so.
as a change because it's a PDF, so I couldn't make
All right.
edits. So
Okay.
it wasn't that important.
All
so
right.
it's fine. We'll leave it as well. I have no
Are
other
we
comment.
set then on this as modified and discussed? There a motion on this?
I bring a
Oh,
motion. to-
oh, sorry. I found out what my comment is. It said somewhere in here, it talks about similar 3 stories. When it's talking about 3 stories, it talks about that it's similar residences in the neighborhood. I don't know what a similar residence is, and I think the word similar should come out and should just say residences.
Yeah, I know what you're talking about. I fixed it.
Okay,
Yeah.
that was it. Sorry, just,
Okay,
Is that it, Robin?
yep.
is
All
there a
right, I
motion?
make a motion to adopt.
Is there a
with the
second?
changes- With the changes we discussed.
Is there a second?
I'll second it.
Okay. Brian,
Yes.
Robin,
Yes.
Greta?
Yes.
Yes, okay, all right, it's adopted as discussed. Okay, we are running tight, let's see. Mamaroneck Beach and Realty Group. We have discussed, I don't have a resolution on that. Oh,
We didn't have a draft resolution. We didn't discuss it.
I know,
Well,
we did discuss it.
hold it.
I thought.
We have the old resolution. I thought that we were basically using that because they
Right.
were asking for a renewal without changes.
Correct.
Before we have the discussion, I would just like to disclose for the record that, I wasn't at the meeting last month. And I did listen to the recordings. The first part of the recording, this was the first application discussed. The first part of the recording was cut off, so I didn't listen to the whole recording. I also, I want to note that the chair or the president of SAPOA spoke, and by virtue of living in the neighborhood, I'm a member of SAPOA, but I want to just say for the record that I'm not, I don't go to meetings. I don't contribute any money. Since I don't contribute any money, I don't believe I'm eligible to vote. So I don't think there's a conflict, but I just wanted to disclose that for the record.
All right, this was the renewal then of the special permit adopted in July 11, I believe, 2019. Okay. I thought they made they seem to have made an interesting and a good presentation. I think they had neighbors. I know the immediate neighbor on the east, who had been vocal in the past, was supportive, as were others. I mean, anyone have any issues with this application? Speak, please.
I have a question. And this was brought up on the first meeting that they had, that the Shore Acres Point Corporation resolution is a lot more strict than this Mamaroneck Beach and Yacht Club resolution. And I don't really understand why that would be, especially since the noise issues are seem to be clearly more of an issue with Mamaroneck Beach and Yacht than the Shore Acres Point Corporation.
If I remember correctly, on 2 occasions that I've been here when they discussed the Shore Acres, there were significant issues regarding control, people being there who were in charge. You had neighbors on the sides, very vocal. It was much more contentious. And I believe, if my memory serves me, and it might be wrong, that there was an issue that there was really no one there supervising, or no one there from the ownership when they were conducting themselves. So I think that required much more at the time. And as was evidenced by people speaking against it and expressing their concerns. Shore Acres was much more. They were also rebuilding the place at the time. They had to do with the outside, the inside. There was a lot more issues there. That's my recollection anyway. I can
Well, I was
remember.
recused, I'm recused from that issue.
Okay.
So so you made your decision, which is of course fine, but it seems to me that the noise issue was much more of an issue with the other club, Mamaroneck Beach and Yacht Club, this particular
Okay.
application.
Okay.
So and I guess this is the other important distinction, and you can advise me. The resolution for the SAPC can refer to all events, whereas it seems like with the resolution, the resolution for Mamaroneck Beach and Yacht Club is just really referring to non-member events. We have restrictive conditions for non-member events, no conditions on member events, but the other resolution, there are conditions on member events. So I guess one of my questions is, do we have the authority to make conditions on member events if we wanted to?
Which events?
Do we have authority to make conditions on member events as well as non-member events? That's a question I'm asking you.
You're only issuing
No,
a
yeah,
special permit with respect to
to the non-members.
non-member events.
Yeah, that's the
We'd be
special permit is for the
essentially making-
non-member events.
Okay,
Unless we somehow felt that the non-member event affected the member event, and I don't see how
Yes.
that would. So
okay.
I don't think we can. As much as
All right. Robin, any comments on this application? Brian, any comments?
Yeah, nothing,
Okay.
nothing too big. It's just, we went through and just going through with their old application, or their old special permit. We don't have any documented, complaints, police, violations, on the event. So although there have been complaints of noise, the club has made substantial efforts to explain them. The one that was the most recent turned out to be
Yeah.
something that was unexpected by them. It was a traditional
Indian
thing.
thing.
Yeah, I didn't want to go to anything specific, but where the person lived or what their background was. But that it was a one-off type of a situation, which was not set up by them. And they did take a lot of time to explain that. So we don't have any negative police reports against the club during their time of this special permit. And although people have, said things about a certain noise, some of those were on member event, times. But really, in the end, in the absence of having police reports showing a violation of the special permit, I really think that goes to the applicant's benefit in terms of renewing the permit. They're not asking for anything more on this permit. They are very, very well aware of how tenuous their situation is, in terms of the fact that, they do live close to a residential neighborhood. But I think that they've also made efforts to work with the neighbors. And as David said, the neighbor immediately adjacent to them very succinctly said, look, they're a club and they're trying to run this place like a club. They are a known entity, that has been in the neighborhood for decades and decades. And that, if we're not going to help them run as a club or give them permission to run as a club, we have the condo option back on the table. And I think that was an interesting thing to hear from the neighbor, immediately adjacent to it. So aside from that, I think the form that they have to file, what was it exactly, Charlie, that they filed? Do you remember?
Yeah.
Because that would have to be revised. It's not a 990. What was it that they said?
I can't recall off the top of my head, but it was some tax form.
Yeah, it was a,
990 wasn't applicable because they were not member events.
Then let me
Right.
ask you, did they, I understand, and I'm not a tax attorney or an accountant, that the 990 and 990T, which that's what's spelled out as a condition required in the current resolution, that those are forms for not-for-profit corporations that you file with the IRS.
Right.
What evidence, and being a not-for-profit entity is a condition for this special permit. What evidence have they given us, verbal or otherwise, to indicate that indeed they are the IRS deems them a not-for-profit entity?
I thought that the form that they said they filed, because
Yeah.
the form, whatever the form of the entity, the Mamaroneck Beach and Yacht entity is, it couldn't file the 990, whichever, and it had to file this other form, but the other form was also for a not-for-profit. There are many
Yes.
forms
Yes.
that not-for-profit can
that's correct.
file,
Yeah, we
not
would
just
have
the
to.
990, depending on what the particulars are
Yeah.
of the.
So maybe what we should do is phrase the condition as
Make it the applicable form.
tax documentation evidencing that they are a tax exempt not-for-profit.
Or required because they are.
Yeah.
Yeah,
Yeah.
that would
they
be
did.
under subsection E, Charlie, okay?
So if
The
you,
other thing is that we might want to make them have the record keeping of all non-member events.
Yeah, it's skimpy. They need to.
Yeah, well, no,
it has
I
to
said,
be
so
much
what I'm
more-
saying is that, I understand that, but I'm saying what I think they should put in there, Charlie, is a provision that says all, they shall maintain contemporaneous records available to the village and the board that indicate the date, the name of the sponsor, and
type of event.
the type of event and the time of the event, and the name of the non-member who's running it, sponsoring it.
okay,
All right,
I'll add that to a draft resolution.
thank you. Anything else on this?
Yeah,
I'll just-
on the last page, item G.
Yeah.
It's just a typo. It says that nothing should be done after 10:40 a.m. on Monday
Oh.
through Friday.
Well, it's
So
for
I'm-
breakfast. You mean PM?
I think it should be
It-
changed to PM.
I was just gonna
Or
add,
Greenwich Mean Time?
I was looking at their application, and if you look at the May 6th letter from Mr. Wexstein, they do reference the tax form, and then there's an affidavit from Mr. Riccati that's in the application that also talks about their filings with the IRS. So that is in the record.
Yeah, I know that we questioned them and they did tell us the specific thing that they filed as well. We'd have to go back, but if you have those forms in the record, they should suffice. I don't think that necessarily changes what
No.
David's suggestion, the writing should be, or Greta suggested.
So I have conditions as one being proof of their incorporation of a not-for-profit, contemporaneous records indicating the date of events, name of the sponsor, and the type of the sponsor,
Right,
and then correct the typo in item G of the prior resolution.
right. Okay, we set the vote on that?
I have another suggestion, which you guys might not agree with. Given the level of community concern that was expressed and
Was there?
far more than typical in applications. I would suggest maybe we give them 2-year special permit as opposed to 3-year.
Was there that much
I thought
community?
it was, I thought it was the most I've ever seen in the 3.5 years I've been here.
All right, maybe I'm just, on this application? let me just- Actually, I thought it was very positive, most of the people. I didn't,
We had all these emails, that we got.
yeah, but they all related to one, didn't most of those all relate to one event?
Yes.
The
Well, I mean,
latest,
but it was,
No, they related to one event. That was my recollection.
they had evidence of that. But then you had the Bleecker Avenue petition.
Right.
And you had people speak. And it wasn't all about that one event. I thought it was a lot.
Well, I think if you look at the number of events they have over the life of the special permit, which is 3 years, and then the number of events that were actually complained about, yes, there was a lot of people making mention, but the club was substantially able to square away, that they were, like the last one where they had a lot of evidence. It happened to be a family from Shore Acres, and then they decided to do a brief but loud
No,
traditional.
they explained that one for sure. They
ceremony.
definitely explained that, but
Okay.
even before that.
And then the other one, the one with the Bleecker Avenue, I think was explained by the fact that every year they had like a prom, and it was a COVID year, and they kept the door open because of just to get more airflow. So they did have some. I think in the totality, although there were a lot of voices and there should be a lot of scrutiny, I wouldn't think it's substantial.
Well, 2 years, is just kind of saying you're getting the special permit, but we're mindful what the community said, and let's just see if there's an issue in 2 years. And if there's not an issue, then you give them a 3-year.
Yeah, the only reason why I have a pause is because of the costs to the applicant. If they're insubstantial to come for a special permit, then yeah, I have no problem with it. But if it's automatically going to cost the applicant, a good deal of money, then it's something I give a lot of weight to.
Yeah.
So what are the
I would be
costs?
I would be comfortable with 3 because you've already, when did they make the application? In May?
That to me is not, to me, the issue is we've given, it did not
Yeah.
strike me as there were so many more complaints than previous years. It also noticed that the current administration of the board seems to be taking better control of what was going on. And I think the biggest problem, which is not a problem proposed by them, is the problem in the village code of how we define member and non-member events and what that leaves for member events to be, and the fact that the vast majority of the events have members of the public and not club members. And the only difference between a member event and a non-member event is whether a member of the club sponsors it. So as
Yeah,
opposed
that's a huge problem. I agree.
which is not something we can do. And so it's very hard to distinguish between, when neighbors are complaining between member and non-member. Who was it who made the noise? Was it a member of the public who made the noise? Was it a member of the club? And it's,
Okay.
but we've given them 3 years, and I didn't think this was so much worse than the prior.
Yeah, I don't think that, Rob and I agree with you. I think we've given them 3 years, and to cut them back to 2 is actually to say they haven't done it correctly. We would do that if there was an issue. I don't see this as an issue. I see this as a positive so far, but.
And again, my
Okay.
problem is, there's no actual police report or evidence, and, we're affecting the applicant. If they had 3 or if they had 5 verified, violations by the
Okay.
police, that's a different situation. They don't have any.
I don't think,
All right,
as far as
so-
I'm concerned, police report is not relevant. I think.
I understand,
the
but
fact that
can
the
we move
neighbors-
forward on this, please? I don't want to rush everybody, but we are past the timing, and I mean, if it's not relevant, go ahead.
I just want to say, to me, the fact that the neighbors complain is significant enough if there's sort of evidence that it wasn't just
I
one
agree.
neighbor saying it
Yes.
was noisy. Because I don't know, otherwise we're saying to the neighbors and to the club, if there's a problem, you should call the police, and therefore we're telling the police, you have to take this when this is really not necessarily where the police should be spending their time. So I trust I think we have to rely on the neighbors' good faith. If they call up, the fact that a neighbor has to call up the club every day for a month, if that was what it was, and complain, it should be just as serious as if the police issued a violation. So I don't think that's not relevant to my consideration.
Okay.
I don't think it
All right,
should.
is there someone making a motion on this? As discussed with those modifications from the last one?
I'll move as discussed
Okay.
with the modifications.
All right, is there a second?
I'll second.
Okay, Robin,
Yes.
Brian?
Yes.
Yes, Greta?
All right.
Yes, I'm sorry.
I suppose, yes,
You suppose, okay. Well,
yes.
Okay, and I vote yes. All right. Okay. If we can do this quickly, if not, we will defer this, but we have one, I wanted to get to one last one, and that's on 830 Orienta. Application was made in May. Area variance, let's see, 09 AV 22. Area variance to locate the garage to the side. The combined side yard problem. Okay, survey, we have this. There are comments and discussion with regard to this one. Anyone have issues either way with this?
I think it's fine. I
Okay,
went to look at it today. One thing that I thought was important to note, when on the opposite side of the house, there's not another house. So there's not a house that looks directly at it. So you have the 2 side houses, and then right across is just lawn or trees. So there's no visual impact on the other side of the street at all.
If I remember correctly, there's a lot of blinding by shrubbery and trees on the side that they want to put the garage. And one of the benefits to what they're doing is they're going to decrease impervious surface. So I think that's a positive.
okay. I'm good with that. We don't have a proposed resolution on this. Do you want to vote on this, or do you want to have a draft resolution to look at?
I prefer having a draft resolution to look at.
I agree with Robin. Can we just?
Okay,
can we
fine. So
put
we'll
this-
have that. We'll have a draft resolution for this. It'll be for the next meeting. Can you get that to us next week, Charlie?
Yep.
Okay.
Dave,
Resolution.
before you just go on, we had we did have this thing for Duke's Ramen. We were only missing one item
Yes,
from it, and did we have a resolution set up?
we
for
do
it?
have a resolution. I was going to come to that. I had one other ad first, but okay, 1 second.
Okay.
Resolution
have-
to be
Did we
prepared.
discuss the resolution last month?
Just 1 second. It'd be, what's the number on that one? That's A1. Hold on. I believe there's a resolution on this that was prepared, and there was on Duke's Raymond. This was a question about how it's going to be classified, correct? Charlie, is that right?
Yep, that's one of the items that the board had yet to deliberate on.
Right. I think on the balance, the board was, and then what time it will cease for, if there's acoustic music? Is there, did they propose music?
No,
They didn't,
No,
but that was just something the board has been putting in restaurant type of resolutions, but it
Do
might not
you have a
apply.
recharger
But
for
where
this?
do we have a draft resolution on this?
for Duke's Ramen?
Yeah, it was provided some time ago, actually, I think.
It was emailed on Tuesday.
Yeah, and I could not find any of those resolutions, and I'm sitting at what's on the agenda and I don't see it. So I didn't look at it.
It's the last page under 154. It's the last item that was uploaded to the agenda under them, under the attachments.
You have to unthread all your emails.
Yeah, and I could not figure out how to do that.
Yeah, I know.
Oh, there's
Right,
the draft
so
resolution. I haven't
Robin,
read it, and so I can't vote because I haven't read the resolution. I don't know what it says. So if you want to vote today, I'll just abstain.
Well, should we do it? Should we do it? some
We can
other,
do it.
I'm not saying that if that's what you want to do, that's fine. I'm not saying you have to wait.
I understand, Robin, you're clear.
So.
well, maybe we should do it July 28th then and go on to the executive session.
No, there's
Well-
something else, just a moment, before we get to that.
Do we have to vote on this today, Charlie?
No, do we have to, I don't think so.
No, you do not.
well, we don't, but understand that they can't open their business during, every week during the summer is meaningful. I don't know that there's that much to deliberate on,
I
the
agree.
question is whether or not it's a carry out or not a carry out.
I agree.
And I think that, Greta, your question, I think it was your question, which was very relevant. You asked, or somebody asked, what percentage of their business is takeout?
Yeah, the 60/40. I asked that today, I thought.
It was 60/40 because the whole definition rests on whether or not the counter is incidental. And I
Right.
would say clearly the majority of the business is going out the door.
Is 40% incidental though? I mean, I guess. I
We have
wonder.
not, I think on previous things where we tried to decide that 40% was not necessarily considered incidental. So,
Well, they haven't been up and running. So we don't have actual figures.
Right.
You could actually make this very limited. You could do it for 1 year and then they could keep records. At the end of the day, we don't have many choices in
Well, we
terms
can
of.
say it's a food service establishment.
We've
Yeah.
been down that road before with Chopped. And I don't think
Yes,
food service establishment is a defined use in the code. It's just labeled as the special use permit standard. So it's either has to be a restaurant, a carry-out restaurant, a fast food restaurant, which I don't think anyone proposed that it was.
Right. Right. And it's not a restaurant. And it's not, it doesn't seem to be fast food either.
No, I don't think it seems.
I think
No, it's not.
carry out seems to be our best choice out of the three, at least, well, that's just my opinion. Because there's really not much to choose from. It's not a brew pub.
so you want it to be. All right, Charlie, and on who prepared it? I guess it was the applicant prepared it, right?
Prepared.
You have a place here for who prepared the drawing, right?
Yeah, so I'll add that in.
So I guess it's the applicant in consultation with the building department.
Yes.
I don't think we need the sound thing. They're not proposing music by putting that in, aren't we?
I don't think we should say anything.
I
Yeah,
think you're right, Robin.
Yeah,
Okay.
okay,
I have a couple comments. I'll just read through them quickly.
please.
You guys
Are we
can-
going with carry out restaurant, just so I know?
Yeah.
Yeah.
For the first paragraph, when we say wants a special permit to operate a restaurant, I wouldn't, since restaurant is defined term in the code, I wouldn't use that word. I would just say to operate and this is from their application, a fast casual ramen noodle soup restaurant. That's what they said. That's what they applied for.
Okay.
And then if we're going with.
And that would be the same for the second paragraph too.
Yes.
Right,
If we're going with restaurant carryout, I don't think we need the definition. This is page 2. I don't think we need the definition of restaurant above.
Agreed.
right.
Right.
And then that whereas clause after the definition of restaurant carryout, I would say, but it's prepared on site on a per order basis, and then say which includes both carryout and delivery options and limited counter eating to 10 seats. So we can kind of de-emphasize the eat-in and emphasize the carryout and the delivery.
Okay.
And the other thing I would just make, sometimes in this resolution, we say the village, Charlie, but we don't define the village.
Okay.
So either we should define the village or we should just say the village of Mamaroneck.
Okay, I can do that.
Okay,
And then under, I guess, page 3, number 3, the application is in compliance with special permit standards and requirements as set forth in sections 342-45 and -71.
is there a reason you don't want to just say the code, the requirements?
Well, shouldn't we just, this is,
Sure.
these are the special permit sections.
Okay,
So I just thought that would be better.
okay,
Oh, I saw a typo.
how many years?
How many years?
3?
Yeah. Do 3. And then we'll reassess.
Okay.
Reassess. Whether
Taking
there's
that E.
a carry out. I saw a typo, Charlie. Oh, well, you're deleting that paragraph anyway about the music, so.
Yep.
That becomes moot.
Okay.
Okay.
Is there a motion on this? You want to move on this now? As discussed?
Yeah, I make a motion to adopt as discussed.
Is there a second on that?
I'll
I'll
second.
second. All right. Brian,
Yes.
Robin,
Abstain.
Greta?
Yes.
No, well, yes, okay. Okay, 1 second. All right. That ends all of the matters that we're hearing or closed. One of the items I just wanted to discuss, I wanted to just go over, just made a decision on the procedures, conferring with council. There was an application made on May 20, 2022 by Susan McCrory and Stuart Tykert regarding an appeal from a building permit. There's a question as to whether or not they're standing or not. And I did not receive this until the end of June. I believe I received it from council. And after reviewing the cases, it's difficult to separate out. The question was, do we hear standing first and then the application? And after discussing this, reviewing some of the cases and discussing with council, no, I think that we've always, they're integrated. The concept that they're factually sensitive, the question of standing, because it deals with impact. So it will be on for next month, and they can, for the next meeting rather, it'll be the first on. And it will be for the whole thing, they'll address it at that time. It was, I mean, it's been delayed for some reason, and it should be on one way or another, get it resolved. So I just wanted to point out, one of the issues that will be raised will be standing of the applicant, whether they have standing to challenge it. And then, but that also then they can go to the merits, because the merits do have the question of the impact, impacts how one addresses standing. So I just wanted to indicate that to the board. There are other items, but given the hour, I mean, I think we can go to executive session just for the pending litigation. And then we can, and also I think we should hold the next meeting and keep the number tight in terms of the, there's 4 new ones, and probably doesn't include this one, so there's 5. But we're not going to meet in August. So I guess we'll take the 5 and we can then deal with some of these other items. With regard to the procedure of the Board of Appeals, there have been changes made to the procedures. I have noticed that one of the changes, according to the web site, indicates it was made on a day when there was no meeting held. So I have no idea how that was done, because under the code, we set our own procedures. So, but we can take that up, and what I'll do is, I've talked to Greta. We can maybe have some of the information pooled, so we can at least get some outlines of the issues, so everybody can put their ideas in.
David,
regard-
I'm confused.
Yes.
What issues on what procedures? What was changed? I don't understand. I mean, I know you said that.
Okay, well, I'm not going to go into now. You could take a look at the applications, and I'll send them to you. But the applications, the one online, for example, one of the things it goes to is the amount of escrow and a whole escrow procedure, but they indicate that the procedures of the board, give me a second, I can pull it.
Can I ask one
Okay,
question?
on the zoning, let me just show you right here. I have it right here. It says here, revised document submission guidelines was adopted May 7, 2020. Oh, this says 2020, and yet others of them indicate they were amended, the application was amended 2022 update. I'm not aware of anything that was done in
The
2000.
ZBA application update was strictly for the escrow. Our escrows have increased and we updated them to reflect such. And I also changed the amount of copies because people were bringing 16 copies.
I
into
understand.
office.
Brittany, I'm not arguing with you. I'm just.
No,
trying
but
to
I'm just
explain.
confused which procedures, like Robin
Okay,
asked,
well,
what
the
procedures we
escrow
were
would be one of
discussing.
them. The escrows were changed. That has to be addressed by the board, I think. Because as I've indicated in the past, and as the board has indicated in the past, the escrow provisions seem to directly conflict with New York procedures and laws as determined by the New York Court of Appeals and the Second Department repeatedly. And that poses some issues. And also, if we're going to change the procedures, with all respect, they need to be changed by the board. So we will deal with that at a later time. But I just want to take that up. We can take those things up later at the
I
next
have
meeting.
2 questions as far as next, the 28th agenda for 700
Yes.
South Mary, Mamaroneck Beach and Yacht. I know you have some, you want to write up the draft resolution. Will that need to be re-reviewed at the 28th, or is it? No.
No.
No?
It'll
Okay.
be, it will be on for, you'll get the agenda. We'll go over the agenda. It'll be it's on a closed hearing agenda. It will be on a closed application.
So the draft will have to be reviewed at the 28th meeting.
I don't know if it will or will not be, but I'm saying it is a closed application. So it will be listed as on a closed application, as the application is closed. It has not been, there's no resolution. We will have the resolution before that and the board will vote at that time.
No, we
I
voted
thought-
on
Just
that.
it.
No, it was
Oh,
voted
I'm
on.
sorry, excuse me. Oh, I'm sorry. Which one are you referring to, Brittany? I'm sorry.
700,
Yeah.
No, it will not be on. 243 will not be on. 154 Mamaroneck will not be on. 830 Orienta will be on the agenda as a closed application.
okay. And my other question was for Charlie. I just want to make this clarification so I have all my, everything right, because I have to send out the information by Monday. For the appeal for the application for 886 Orienta, a sign is not required, but a 400-foot radius of mailings is around the subject property, correct?
I believe so. I think I emailed you.
Yeah, I just want to make that clear.
Well, if he emailed you, what did you email, Charlie?
The notice requirements for an interpretation.
Okay, I was just told that in the past, those appeals have not had notification requirements, and I just want to make sure that when I speak to the applicant, that that's made clear.
Yeah, I'll check again, but that was my reading of the code.
Okay, all right, just want to be clear. Thank you.
And when does that have to be done by?
I have to send that out to everyone by Monday, all applicants for the 28th.
Okay. Do you send out the notices or does the applicant?
I have to send out what they need to do, the radius. I need to give them all the affidavits, and then they send them out themselves.
Gotcha. Okay, super. Okay,
Well,
and then
now-
you said we have 4 new matters on for next month? For the next meeting, is that right? Brittany?
As of right now, we have 4, and then 416 Waverly.
Charlie, is there a timeline for those notices? In terms of how far in advance they have to be sent out prior to a meeting?
I'm sure there is. Let me just.
10 days prior to the meeting.
Okay. Well, then you're able to get it.
I don't
in.
know. Is that the,
Yep, and then we have to have proof within 5 days.
which is the Waverly one? I'm sorry.
416 Waverly, the FEIS, they're dropping off documents tomorrow to be on the 28th.
Okay, well, we'll see if they go, I don't know. Let's get the documents first. We'll go with that. So you're gonna have 4 plus that. The 4 includes McCrory and Tickert?
Yes,
Okay. All right. And when's the cutoff date for applications? Tomorrow?
it was yesterday, I'm sorry,
Oh.
today, but the ongoing matters like Waverly is the 14th. 2 weeks prior to the meeting, 3 weeks for new.
Okay. Now, did they drop off anything yet? No.
They're supposed to tomorrow.
Okay. Super. All right. Well, why don't we do this? Let's go into executive session if you want to discuss the pending Article 78 briefly. Is that all right, Charlie?
Yeah, and I
Is there a
think
motion on that?
that was a link that was forwarded to the board by Brittany. So use the.
It's a
executive-
separate link.
Wait, there were 2. Didn't Charlie send a separate one?
That was only if the board wanted to go into advice of counsel session, but you should use the link that Brittany sent for the executive session.
Okay. Could somebody forward that to, so we're gonna change. Okay.
So do we have to close this meeting?
I keep it open. Oh, I'm sorry. Sorry.
You have
Yeah,
to
we have
keep
to
it
cl-
open and then come out of executive session and adjourn the meeting.
But don't we have to leave this, we each have to leave this because you can't be
Correct.
2 at once.
I'll put the executive session sign on.
Yeah, wait a second. I because my machine is down at the other one. So this is,
You want me to send it to you, Dave?
no, I'm looking here, just a second. Brittany, I think I have it. If I forward it from this, I think it can do it. I can, machine works that I can forward something. It just
Open that meeting.
has met a sudden, okay, all right, so. Is there a way we can't, I see, so we can't close this, we have to then come back to this?
We have to leave it.
Yeah, you leave it. I will keep
Charlie,
it open and you
is there
can
a way-
come back to it.
Charlie, I have a question for you.
Sure.
With regard to the discussion concerning the pending litigation, is there anything of a privileged nature that will be discussed?
Yes.
Okay, that's a fair answer. Okay, so I would basically close this and go to another,
We
right?
need- Charlie, do we need to vote to do this? As I somehow.
Yes,
have
we
this
need a
sense that-
motion. We need a motion to go into executive session to
That's
discuss
what I
pending
thought.
litigation.
You want to make that motion, David, since
Sure, I made it. Is there a second?
I'll second it.
Fine, but, okay. Brian,
Yes.
Greta,
Yes.
Robin,
Yes.
and I vote yes. Okay. So we leave the meeting and go to the other one. Oh, it says oh, I see.
Okay, I'm going to meet you guys on the other side.
Hopefully, we're all there.
Now I can't leave it. It won't let me. Where's the,
Yeah, maybe I can try this.
oh, I
Let's
got
see.
it now. Okay, leave. I got it. Leave.
Okay. Charlie, is that you? I really can't see anybody, so it's sort of interesting.
You have to get out of the other.
Who, I have to? Huh. Yeah. I'm gonna jump off the meeting. Hello.
Hello, long time no see.
Yeah. I see that green dollar sign. Do you see that? My wife is, show this to you. See? Can you see it? That's equal pay for women. That's a women's, Beverly has been founded and leading this equal pay for women. She's in New York. Okay,
Well, at least we've now, maybe I'll have a constitutional amendment, so that's good.
that would be nice. She just heard you say that and she went, yay, Rob, and she's busy with. She says she's working on that. You get Letitia work?
Well, I mean, now it's up for the vote. The governor is going to sign it, and so the bill will be passed. Then it's just up to the.
No, she's
public.
saying no. You got to call her separately. You can look online at Power New York, POWHER, I think it's NY. But give her a call. She'll love to explain it. I think she's had it talking to me anyway. All right, it's been a pleasure. Is there a motion to close?
Dave,
Wait,
did you
do
want
we
to?
need to say
Charlotte,
that we
what?
went? I thought we discussed that we needed to
Right.
say that we.
I
went
just wanted to point
into-
out, I'm sorry if it wasn't pointed out earlier that we were in executive session regarding impending litigation in the form of an Article 78 in the Supreme Court of the State of New York, County of Westchester, which is presently pending. And we were discussing the defense of that case and our position so that the court could be fully apprised of the facts and circumstances and the legal arguments. And discussed this with Mr. Gottlieb, who has been conferring with his colleagues at his firm concerning this. Okay. Do you need the name of the case as well? Would you like that on the record, Charlie?
You can just reference that it was related to the 524 Waverly application.
Okay, it was
If you'd like.
related to I could say that just as well. It was related to the 524 Waverly, just referenced by Mr. Gottlieb. And on that pleasant note, is there an application to adjourn?
I so move.
And okay, and everybody should move if they agree with that, but is there a second? Then we have agreement.
A second.
Okay, very good. Brian, everybody, good evening. Greta, Charlie, Robin,
Right.
have a wonderful week and a good evening, and we'll see you sooner than you'd expected.
Take care.
Stay well, everybody.